Good evening and welcome to the February 2015 meeting of the Lopatcong Township Planning Board. At this time, I invite you to join us in the silent moment of prayer, followed immediately by the oath of allegiance to the flag of our country.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Is that us? Or? At this time, I'm required to state that adequate notice of this meeting has been provided indicating the time and place of the meeting in accordance with Chapter 231 of the Public Laws of 1975 by advertising a notice in the Star Gazette and the Express Times and by posting a copy on the bulletin board in the municipal building. You have a roll call, Beth, please?
Yes. Members Belcaro.
Here.
Weimer. Here. Dagan. Fishback. France.
Here.
Corral. Paul.
Here.
Liptak.
Here.
Mayor McKay.
Here.
Vice Chairman Pryor.
Here.
Chairman Van Vliet.
Here. Move on under old business. Has everyone received a copy of the minutes of the last meeting? Are there any additions, corrections, or comments?
I have a comment.
Yes.
I noticed looking at the minutes that we did not elect a secretary among our officers.
Yeah.
Is it that we intend to have no secretary?
No, the secretary has a 5-year contract starting last year.
I would ask our attorneys, is that appropriate to have 5-year contracts for officers of planning boards? I thought they had to be 1 year.
It's something I haven't researched, and I must tell you I'm not really familiar with the question. I understand that boards are this board is autonomous from the governing body. The governing body, however, provides funding for this board. So there's this interplay that's there. I'm not aware of any reported decision that addresses the issue head on, but Mayor, I'll be happy to look into that and report back to you at the next meeting.
Yeah, I went to the course for planning board on Saturday, and they went over that, and that's what they said there. So.
Did anyone there express an opinion to you?
The attorneys that were on the board said that was the case, that you could only have 1-year appointments for officers. Non-officers, you could have like a long appointment. You could do something different, but for officers who had, signed papers and such, the maximum term was 1 year.
I don't think there's anything in the Land Use Act that says one way or the other, but I'll be happy to research the question.
Okay, just don't want us to get in litigation problems down the road for something silly like that.
Understood.
If I may ask, what is considered an officer? Because as I read minutes and look at things, everything says class 1 and class 2. What's considered an officer?
I don't know. I could have to defer to the mayor on what he was referring to as an officer.
Well, in the minutes, it's under the reorganization section, and then there's the election of officers and secretary section. So the officers would be, in my opinion, and I'm not a lawyer, but they would be a chairman, a vice chairman, and a secretary in this case, in an organization such as this. We're the members, we're various levels of members. So we're like the board, and those would be the officers who carry out events. That's my non-lawyer understanding of it.
Further discussion? If not, we'll wait until we get an opinion. Any further discussion on the minutes? No comments? In that case, the minutes will stand as published. Moving on to contracts for the year 2015. First one, resolution number 15-6, approved contract with Paul Sturman's Major Consulting for engineering services. Do you want to do these in total or each in one individually?
What do you recommend?
I think you can do the another job.
Okay. The motion in, memorializing the resolution. Here a second?
I'll second.
Is there a
Roll
term
call
on
back.
these contracts? I couldn't find a term. They're all
For 1 year.
All 1 year? Yes.
My contract says 1 year. It expires December 31st, 2015.
Okay.
On the last page.
Roll call back, please.
Oh, wait a minute, is there discussion?
Oh, okay, discussion.
I just, when in reviewing this, I saw Paul offered one rate for escrow work and a different lower rate for other work. I was under the impression that the municipal land use law required that that rate be identical. Again, I'm not an attorney, but that's been my impression.
I think it depends upon the nature of the work. Again, it's not something that Paul just handed me a section of the Land Use Act, 4055D-53.2, something highlighted. Well, what's your understanding of this? I'm just looking at this for the first time. I didn't.
Seem to suggest that the going rate should be uniform across the board. And just to give the board, when I started many years ago, I was asked to have a lower rate for my general time. Sometimes it's general time when we go to these meetings, reviewing policy issues, ordinances, master plans, things of the like. And I've continued that practice throughout the years, is to keep a slightly lower billing rate for the general work. There isn't a lot of general work, quite honestly. If it's more than $500 a year, I'd be very surprised. So, so I guess the implications of this is if we follow the statute here, all my work would be 145 instead of, including the general work, which right now I'm indicating should be billed at $120 an hour. So.
And the statute seems to distinguish, it requires uniformity when these are fees not reimbursed or otherwise imposed by applicants or developers. So that suggests to me that review work could be at a separate rate than work that's done for the municipality that comes out of the budget that is appropriated.
It suggests it could be a different rate or the same rate.
It suggests to me that the limit here, it says, for other professionals, the charge shall be the same as the rate as all other work of the same nature by the professional for the municipality when fees are not reimbursed or otherwise imposed on applicants or developers. Again, I'll look at this more carefully. It's an issue I've not wrestled with before, but I certainly am familiar with the fact that you've got professionals and persons that are on their staff that may be billed at different rates with different levels of service and
Well,
different.
Paul's contract has a fee schedule, and the fee schedule, if I understand it, is the same, except for the principal. Correct?
Yeah, what would happen is, I'm the principal, so.
I mean, that's the only rate that's different, right?
145, if there's a general activity, I charge 120.
Yeah.
So. that's
I'll say 145 for a principal is still a bargain.
Maybe it should all be 145.
It's only a few bucks. It's a bargain. I think that puts us in compliance with the law.
I have no problem.
Yeah, we wouldn't turn down
Just on page 2, after it says $145 an hour, I would eliminate the rest of that paragraph, except in cases where general work such as ordinance review, general meetings are considered funded from the municipal operating account. And I said the hourly bill rate for the
impression share side of the 24 for general work should be $120 an hour. I'll just take everything out after the $145 an hour. And I don't think it's going to be a major impact. There's very little general work that takes place compared to.
I mean, I would support that. The dollars are small, and I think it brings us into compliance with what my impression of the law is. If somebody feels differently,
I've modified the resolution that I prepared, and well, I will send. I'll clean it up so that we have a clean copy. And I'll also modify the agreement for professional engineering services that I prepared with that request.
Actually, I prepared this agreement. I'll just go back and amend it and send page 2 back tomorrow.
That's fine.
Can we act on it tonight, or do you want to wait for
We can adopt the resolution.
resolution with those provisos of the change?
Yes.
Okay. I'll ask for a motion for adopting the resolution with the modifications that have been stated as far as the fee schedule is concerned.
again, I'll make that motion.
Okay, do I hear a second?
Second.
Is there further discussion? None? Roll call, Beth?
Members Delcaro,
Yes.
Slimer, Grant,
Yes.
Paul,
Yes.
Liptak,
Yes.
Mayor McKay,
Yes.
Vice Chairman Pryor,
Yes.
Chairman Van Lee.
Yes. Moving on to the next resolution for adoption, approve a contract with George Ritter to provide planning advice to the planning board. Do I hear a motion to adopt the resolution?
So moved.
Do I hear a second?
Second.
Discussion? Hearing none, roll call, Beth?
Members Delcaro,
Yes.
Slimer,
Yes.
Grant,
Yes.
Paul,
Yes.
Liptak,
Yes.
Mayor McKay,
Yes.
Vice Chairman Pryor,
Yes.
Chairman Van Lee.
Yes. Next resolution, 15-8, approve a contract with Anthony Spizzaro to provide legal advice to the planning board. Do I hear a motion for adoption of the resolution?
Motion. Second.
Discussion? Hearing none, roll call, Beth, please.
Members Delcaro,
Yes.
Slimer,
Yes.
Grant,
Yes.
Paul,
Yes.
Liptak,
Yes.
Mayor McKay,
Yes.
Vice Chairman Pryor,
Yes.
Chairman Van Lee.
Yes. Applies the contract. Move on to resolution 15-09. This is to grant the Phillipsburg Mall an extension of time of 190 days. Has everyone received a copy of that resolution? Are there any questions, comments, discussion?
In the packet. So,
It's the last one,
Let's
The last one in the packet.
the last 2 pages, at least in my packet.
You have it?
yes.
Oh, okay.
Hundred and 90 days is correct versus 180, or?
190.
What the statute says.
It's an odd number, but I can pick it.
This concerns Friendly's Restaurant over by the Phillipsburg Mall. If you're wondering where it is.
And what is the ultimate goal of the resolution?
The mall was sold, and all the peripheral properties, those in Lopat was mainly concerned with just the friendlies. They were all, instead of being one giant lot for the Phillipsburg Mall, they were all sold off to the individual property owners as separate lots.
So everything's
Why they want to
subdivided.
do it, I don't know if it was just to generate funding for the new owners of the mall or what it was. There was some controversy with the friendlies and the fact that we had a, well, kind of, I hate to say a property line dispute, but it was a bound dispute. But it could be a foot or so. You remember that discussion?
But also had to do with the maps that were presented showed a boundary
Right.
line.
Mhm.
However, the map indicated that it would subdivide it, but the subdivision was never filed with the county.
County.
So they came back in to have it subdivided.
So like a friendly restaurant and all that, they're not owned by the mall owners or anything. They're their own separate plots, their own.
Right.
They are now, yes. Before, I guess they were just renting the property, or I don't know I don't know what the arrangements were as far as landlord-tenant association or anything like that. It was just that they cast off the lots as each individual Panero's, or, Sonic when it was there, or whatever it is now. Well, what is it?
Empty.
Oh.
Well,
Sorry about that.
If I remember correctly, the plan was to sell off those lots individually, to use the monies
Right.
to invest back into the mall.
Right.
That was the plan.
They haven't stated the plan now.
Well,
But the plots, Friendly, Sonic, Panera, all those are town plots?
But now individual
So
owners.
they're all individual owners?
Right, they're all private entities. Has everyone had a chance to read the resolution? Entertain a motion to adopt the resolution?
Second?
Further discussion on it? Hearing none, roll call, Beth, please.
Council members Kara,
yes.
Minor,
Yes.
France,
Yes.
Paul,
Yes.
Ted,
Yes.
Mayor McKay,
Yes.
Vice Chairman Fryer,
Yes.
Chairman Bentley.
Yes. Did you get skip?
No.
Oh, okay. That's about it. We'll move on to public comment. You, go.
I have a question. Actually, I have two questions. Olszewski Highlands Way. I was looking over the planning board minutes on the website, and the last minutes posted are from 2013, I believe.
Could be.
Should not be, right?
Why not?
Because the minutes should be accurate, reflected on the website. Last one is posted from July 2013.
Possibility. That was the last one we approved.
You have no minutes approved after July 2013?
No, 14 is.
14.
Yeah, but the last minutes on the website are from July 2013. There are no minutes posted.
Okay.
They need to be posted.
They're not official.
Fine.
Yeah, it's not.
So we just stopped in 2013.
I have a question for the attorney.
The reason for my question really was, and I'm not sure if the attorney can answer that, I noticed the last time that the alternates are voting. They're included in the vote of the board. Is that actually a legal thing to do? I was under the impression alternates are not supposed to vote. But maybe you can clarify that.
Sure.
Thank you.
This is a 9-member board, and if, apart from voting, alternates are permitted by law to participate in the hearing process, ask questions, make comments. When it comes to voting and it's time to vote, if there are 9 regularly appointed members of the board present, the alternates do not vote. However, if there are less than 9 and an alternate is here and is otherwise qualified to vote because they've been here and they've heard all the testimony, then that person can vote. If there were 8 regular members here and an alternate number 1 would have the right to vote. If there are 2 members, regular members, absent and 2 alternates are present and are otherwise permitted to vote, both alternates are allowed to vote. That's what the status of the law is. So they do get to participate, but they only vote in the absence of members who are regularly appointed, and they participate in the order of alternate number 1, then alternate number 2.
And if they did vote, is it no harm, no foul? In other words, it was a unanimous vote, let's say, and they voted.
Their vote really is a nullity. It doesn't mean anything.
Correct.
It doesn't change anything.
Right.
If it was a 4-4 vote or a 5-4 vote, and they voted, say, in favor and it passed 5-4, since there were 9 votes and they were allowed to participate, it would matter. Well, say it wouldn't matter. Their vote would count, but they can only participate if the regular members are not present. Otherwise, their vote just doesn't matter, doesn't count.
So since there are no minutes up, how would one verify that has or not has happened?
Well, there are minutes, but I'm not aware of any requirement that they be posted on the website. I'm certain that you could make an Oprah request and secure copies of the minutes, and you could review them to determine whether or not you find any inconsistencies or problems with that. You're welcome. Mayor, you said you had a question?
Yes, I question, wouldn't it be best if we put the minutes up on the website, so we give the impression that we're not hiding anything, it's full disclosure, there they are, they have the minutes. You know, I'm talking about constructive notice. People don't, really know how to come and look at those minutes, but they do know the website, so.
I think transparency in government is important, and I see no harm in posting them. I don't know what the mechanics are in posting them, how difficult or easy it is, and Beth, I'll ask you that question. What's involved in posting them?
Nothing, I just sent it to our own council president who handles that, our website, and she posts them.
I think it's a good
I think we
idea.
ran into problems though when we had it very voluminous. I don't know what kind of space they take up, and if it would cost additional.
That could happen. If it's too voluminous plans and things, then you could
Well,
set something in there, come to the office if you want to see the plans.
Yeah, because some of our minutes have been like 200 some pages, and you start adding all them, then I think it could cost us more money. But I'm not saying it's, it's a problem, just saying, that's what we would be looking at maybe.
I'd ask you to investigate it. I would
Okay.
suggest that you investigate it, and unless there's a cost or other labor problem that makes it onerous, I think it.
Well, I think it's getting to the point with, from what I can see with council, there seems to be an ongoing problem with them with having things posted on our website, that we have a volunteer doing the website. It's getting to the point where do we have to create a position of a web person for the township in order to get,
Other towns
Who does
do
it?
have that. They do have it.
They do have a paid person?
Yeah, they have a person that comes in part-time usually, 10 hours.
Well, I'm not saying that it is, but it's to make
Yeah,
that
I
one
think that's a
volunteer
very
does
good
it.
idea.
So, and we all know where to go with it,
I
so.
was under the impression that minutes are posted so people who are not able to attend the meeting can still understand what happened at the meeting. That was one of the reasons why, and that we just had that council discussion about minutes and their date of minutes, and I was under the impression the minutes are presented to the public, so people who are not able to attend are still able to
That was council.
any minutes. If you're not.
I have no objection to doing it. It's just what method are we going to use? If we're going to keep depending on a volunteer to do it.
No, I think I'm going to be introducing something where we're going
And this is getting
we need some help there.
to the point where,
Till burnout.
it's nice if you can just scan them on, but if they have to be typed up and,
Minutes are typed up in any case, I believe. So, and since that is my business, I'm in the business of doing that. Posting the minutes is not anything which takes longer than 15 minutes at the most. And if you guys make the decision, I was just wondering why they don't pay us. And we just stopped in 2013, and I didn't know why.
I have no idea why it was stopped.
Okay. Thank you.
We could probably give you a reason from 2014. We didn't meet.
Yeah.
So, okay. Any further comments from the public? Hearing none, I'll entertain a motion to adjourn.
Oh, I got a question, issue with the request that we gave the attorney regarding the secretary. As far as the membership, looking at our ordinance, you know, the 9 members are class 1, 2, 3, or 4 members, and makes up 9. So obviously, if you want to interchange membership with officers, what have you, there's no mention of the secretary there. However, under the organization, it says the planning board shall elect a chairman and vice chairman from the members of the class 4 and select a secretary who may or may not be a member of the planning board or a municipal employee. It may employ or contract for and fix the compensation of legal counsel other than the township attorney, a planning legal counsel, a planning consultant, a civil engineer, and other staff and services as it may deem necessary, not exceeding the gifts or grants not appropriated by the township. So I guess my question, while you research this, is other staff and services, does the secretary fall under that? And if so, then, you know, I feel the board had its right to write a contract for that. So,
I don't think the question is whether it had the right to enter a contract. The question is whether it can do so for an excess of 1 year. I think that's the question. Am I correct, Mayor? Is that the question you're posing?
yeah, I mean, that was what they said at this conference. 1 year for any of the contracts. That's what these gentlemen, other professionals have 1 year contract. That's what you
You
like.
just maybe further expand upon what the mayor just said. I happen to be a panelist Saturday for NJPO. And I was sitting next to the 2 attorneys. And the 2 attorneys took the position that there's really 2 positions. There's a secretary who really is responsible for just signing documents. When plans have been approved, they sign the plans or deeds or whatever. And then you have a clerk or an administrator that really provides the administrative duties for the board. And these 2 particular attorneys took the position that the clerk or administrator is actually very similar to or the same as the board's professionals, the attorney, myself, and the planner. So, and they felt that with board work, all those professionals only get 1 year contracts. So, given the fact that the administrator or clerk is also professional, they should only be entitled to a 1 year contract. So that was their legal opinion that they were indicating to the crowd on Saturday, just to expand upon a little bit further. So that's something that Tony has to take a look
Yeah,
at.
it's
So
a
if he agrees with
statutory
it.
language that says, yeah, fine.
It may be the practice of boards to make 1 year appointments. I just don't know if there's anything that prohibits an appointment for an excess of 1 year. I'm not aware of any authority that says that you're limited to 1 year appointments. I'm not,
Is there a limit, a statutory limit on professionals like lawyers and engineers?
I'm not aware of any in the land use
So
act,
it's-
but the practice is.
To practice it, but if we want to give Paul 2 year or 3 year contracts, we have the right to do so.
That's what I have to look at.
Yeah, I'm not sure that's true, Bruce. I don't think it's in the land use act either. I think it's
I don't think it is either.
It's not land use act, but because it's, I don't want to opine, I'm not, you'll find it.
Well, just from the board standpoint, when we granted the contract, our legal advice was that we could do it,
Yeah.
that there was nothing prohibiting it. That was from our board attorney at that point.
No.
So,
Mistakes are made. Best to make sure we have everything correct.
any further comment?
Well, do we hedge our bet in case it is found that we appoint the secretary? Or do we wait for a decision?
Let's wait for the decision.
I think that would be the prudent
I think we should wait until, give me a chance to research the issue, and depending upon what my research yields, we can then decide how you're going to act. But right now, unless someone challenges it or someone says it's invalid, there's an existing contract, and we do have a secretary, and life goes on.
Will we have to have another meeting, or can you just inform us?
I can generate a memo, but for the board to take any action, we have to have a meeting, and there has to be a quorum, and
Right.
there has to be notice of the meeting. So
All right, so depending on what you find out,
I will prepare a written memo. I will get it to Beth in advance, well in advance of next month's regularly scheduled meeting, and then I'll defer to the chair on whether we're going to have a meeting. There's no other business to conduct. Is that acceptable?
Acceptable. I want to go back to one point also before we adjourn. The situation of voting for the alternates. It's been the practice here long before I was here that the alternates were allowed to vote, but the vote, even though it was recorded, so we knew which way they went, didn't count. In the case that we did have a close vote, or one of the members was disqualified from voting afterwards on an appeal or whatever it would be, instead of having to have to rehear everything, we'd already have that vote recorded as long as they were here with all of the, heard all of the testimony and presentations. But is that legal, or I mean, that was the understanding of what we did?
Exactly.
And it was gone to the first alternate as the designator, the second alternate. If we had two members absent or two members disqualified for something, you would already have that. We wouldn't have to go back and do the entire hearing over again.
The statute says alternate members may participate in all matters, but may not vote except in the absence or disqualification of a regular member of any class.
Right.
So
But
the way I read this is I don't think you can allow them to vote in anticipation that someone in the future might be disqualified. I think at the time of the vote, they're either entitled to vote or not. So respectfully, Chair,
Should we change our?
I don't think they should be, I do not think they should be voting unless at the time of the vote, a regular member has been disqualified.
Okay.
so now,
We're not, right, we're not present.
we want 9 votes. If there's not enough class, non-alternate.
Regular
We
members.
could always go to the alternate.
Exactly, and that's what you're supposed to do.
Okay. So we have a hierarchy of votes. We go down to the class 1 through 4. If we don't have 9 votes, we then go to the alternate.
Alternate number 1, and
And
then,
then alternate number 2.
exactly.
I have one other question, Counselor, following along those lines. Would an alternate be entitled to make a motion?
If they're not entitled to vote, I don't think they can make a motion.
Absolutely.
And I would like to add that I, being an alternate, find problems with that. Not with the motion end, with the voting end. And I would like to talk to the chairman as a sidebar, maybe to that, but my concern and my issue with that is I am allowed and permitted to vote. But as an alternate, and particularly myself coming in, where I'm only 2 months into the position, I don't know all the background and the history of everything that's going on, yet I'm expected to make a vote if something were to come up. So I don't know particularly the history of certain things and where they stand, where they lie, what the parameters of certain things are. I don't know really what is what. So as an alternate, and I know our other alternate is not here this evening, I don't know where he stands on this, but we don't necessarily have all the background and have all the knowledge, but we can vote if there's not 9 people. But if we're voting, then we're supposed to know what all that is.
Well, no, there is no, it's testimony that's given that night.
Or, no, or you had to be present for
Right.
the testimony, or you had to read all the transcripts. So you will, the law says, you must be knowledgeable to vote.
Right.
And you can become knowledgeable either by attending all the hearings or spending an evening and reviewing all the testimony, and then you're allowed to vote. Believe it or not, most of this stuff is covered in the law. Laws are ambiguous sometimes.
No, things are covered in the law, and I understand
Yeah.
that. But when you're talking about specific things within the township, so something is, let's just say, House ABC, something's going on. If I don't know the history of that, and I've just come in, and here I am 2 months into this position as an alternate, I don't know the history. I can't read the history because there's no minutes. I can't back anything up. I don't know anything about it.
Well,
The only thing
we
I
have
can-
minutes, right? We approve minutes every,
What do you mean by history? Because, well, you don't have, we don't make decisions based on history. We make decisions based on the evidence that.
Well, you're bringing people into a position, say this evening,
Right.
where here I am 2 months into this position,
Right.
and you're saying, okay, here is the resolution on friendlies. I don't really know much about it. I don't really know anything about it.
Right. So
But you're telling me to make a vote.
Should have abstained from that.
So,
He should recuse himself from it.
Right. No, abstain. You should have.
so if you're an alternate, you really should vote, because you really don't know.
No,
Because you're
no, that's not true.
No,
because you weren't.
Unless I'm here for 8
Yeah,
months or 10
right.
months or a year.
Yeah, keep in mind, a lot of stuff that comes before the planning board, we hear in one night. So everything you need to know, you're hearing that night.
You know
Very
as much as we
seldom
do
does
about it.
something carry over to another meeting.
How could you hear things for one night and vote on it? That doesn't make
well,
sense.
it may be a small issue,
Yeah.
but maybe I can give you an example of something that's more in line what you're thinking of. I mean, one of the charges of the planning board is adopting a master plan. You may work on that for 8-9 months. You show up at the end of 9 months. Obviously, if that were me, I wouldn't feel comfortable voting to adopt or reject the master plan. So, you have to abstain at that point, I feel. But, somebody comes in, they have, little site plan, it's one night, you want to sit down, review the minutes, look at the plans, if your vote is called upon, you had benefit of what everybody else saw.
Yeah, most of the time, there's usually, when there's a new applicant comes in, which is most of the stuff that we do, it's usually, there's a hearing one night, and sometimes if it's a small thing, you vote on it then. If not, it's carried over to a second meeting. So the most you would typically miss, if you're at the second meeting, maybe you missed the first one you weren't at. You could always go back and read the minutes and be prepared to vote the second time. But most of the time, it's like that. The situation tonight with friendlies and, that was talked about a long time ago, that's not the norm. The norm is more, you got a new application coming in, you hear it for the first time, let's say you're there, you carried over to a second meeting, you hear it there, so you're qualified just like everybody else to vote. That's kind of the norm for the board.
I just wanted to jump in. One of the things that will happen is if there's an application, there's going to be reports prepared by myself and Mr. Ritter, our planner, and we're going to give you a lot of background information on the property and the case. And if there's a history to that property where there are prior applications, we're going to outline that as well. So you're going to get a lot of background information from us on a particular property and application for review before you even get into a hearing setting here, and you get more information through the testimony that's going to take place before the board.
Okay. Getting back to the voting and all that. Trying to think back. Wayne typically isn't here. So he's a class 3 member, I believe. So
Two.
he's the I thought he was
Employee member too.
Okay, 2 or 3. But since he's not here, by default,
at least one alternate should be able to vote.
Correct. He makes the ninth.
Yes, he makes the ninth member. So, and like I said, I don't think he was, I can count on one hand how many times he passed.
So like tonight, you have 2 members that are not here.
Yeah, then both
So
alternates
the
can vote.
alternate can vote tonight.
Like, he can vote tonight.
Vote tonight, correct.
You know, we're 2 members short.
Well, you're 3.
We're-
Right. Right, with 2 members and then 1 alternate. Not here tonight.
Right. Yeah, so, I mean, if we look back at the minutes and everything, I think you're gonna be hard pressed to find a situation where the alternates voted when they shouldn't have, because there was at least 1 or 2 members not present.
Just something we want to avoid in the future.
Oh, yeah. But I always, like,
You're probably
Earl,
right, yeah.
I thought that was the thing, that we're hedging our bet, say that, well, let them vote this way in case a member gets disqualified, that we don't have to have the hearing all over again, that we say, okay, here, use this vote now. But as you said, that's the way the law is written, it doesn't really allow you to have the benefit of, well, just in case, taking that insurance policy out, so.
How would someone, member, be disqualified? What are some of the grounds for that?
Conflict of interest. Yeah, they might,
Becomes known after a while that there's a conflict of interest or something like that.
they might live within 200 feet of.
Don't say that word.
But that would disqualify.
Yeah, I would say so. I only have one scenario that, and with the mayor, he has the authority to appoint someone to fill in for him.
Yes.
How would that, I mean, would that have to be like a term appointment he would be coming to, or could he do it for one evening for him to come in? And how would that affect the alternates?
I will hand it
Put
to
him on
this
the
board
spot.
asking some of the most obscure questions that have been put to me as a board attorney. I don't know the answer off the top of my head. I have to look at the statute. I don't think that, I don't want to speculate.
Okay.
I don't want to speculate. Paul, do you know off the top of your
Actually,
head?
the 2 attorneys, land use attorneys, who were on the panel Saturday with us, opined that they felt it was really the mayor's call. If the mayor wasn't available for a meeting, he can designate somebody for a meeting, and then he could be back the next meeting. The statute's really silent on it, but we did go on to discuss, and actually, I entered into the discussions on this because I've been in a number of municipalities where mayors have made the designations, for the planning board, and really my experience has been is that mayors decide to call it quits. They don't want to be involved in it up front, and they designate somebody, and that person just handles it for the rest of their term. I've seen it in Hackettstown. We've seen it in this town. I've seen it in White Township. They make a decision up front that they're not going to be involved for X, Y, and Z reasons, and they're out of it. And they have a designee, acting in their place, for all these board meetings, I should say, moving forward.
Yeah, in my experience, you had situations where an application came in and it was high visibility. Maybe the mayor would participate in that one, and then when that was decided, they would disappear, and you'd see their representative for the balance. But,
Or just the opposite?
depending on, your political astuteness, I don't know.
Here's a tough one for you. The mayor has a conflict of interest. He sends his designee in. Does the designee have that conflict of interest as well? No.
If that question was put to me, not hypothetically, but in a live situation, I'd say err on the side of caution and have that person not participate. Because if the mayor's conflicted out, the argument's going to be, if someone's trying to upend the board and overturn what they do, that the board that the mayor put someone in his or her place to act on their behalf, and they were just a mouthpiece for the board, for the mayor, and you have got the same conflict and you can't avoid it. I would avoid that like the plague.
You know, straight arrow mayor, you know.
You wouldn't appoint someone?
Not if I was conflicted out.
I think if you're conflicted out, you're conflicted,
No,
as the
no,
mayor,
like-
you're conflicted out, and
For
then,
example, like Mayor Steiner. His partner's a land developer. So right from the onset, he recused himself. He said, I'm not gonna participate in the board. I'm appointing somebody to take my place. Not that he had a known conflict of interest. He just said, the opportunity for conflict of interest is gonna come up, so I'm just not gonna be bothered with it. I'm appointing this person to fill it.
I think that's a different situation.
Yeah, it is. That's it. If you never involved in something, I'd say that's. But if you pick and choose every time.
Oh, yeah.
Right.
Yeah, then that's.
Right.
That conflict, I was just wondering if, like, you get sick one night, and you appoint somebody to come in and fill your position.
Mhm.
How does that affect the alternate situation in voting?
The alternate would not be needed.
Okay?
But the designee that you appoint for that evening would have to be sworn in that evening?
No, well,
Yeah.
They don't have to be sworn in.
No,
Usually,
Yes, they don't.
in my, well, I don't know.
Go ahead.
But, I mean, the alternate serves at the pleasure of the mayor. Mayor's term is coincident with his term as mayor. He appoints a mayor's representative who serves at the pleasure of the mayor. The mayor wants to replace him in the middle of the mayor's term, he does it. But it's not like, you know, this guy at that meeting and this guy at that meeting. You appoint the mayor's representative. He serves until the mayor doesn't want him to serve anymore.
So in terms of what you're saying,
Well,
if the mayor falls ill one evening and he can't attend the meeting, the structure of council, planning board, whatever you want, does not defer to, if you're out, it does not defer to the chairman. Is that not how it works? Is
I'm thinking if he falls ill, he just doesn't show. And the board composition takes.
yes, but he could appoint someone.
He could,
to
but
come if it was an
But see,
important vote.
to me, that, like you said, that would cause the situation, wait a minute, why is he appointing somebody? But if you get sick and don't show,
Because that's what the statute says.
Right.
It's written right into the statute. And it says, you know, how the mayor serves, it discusses the mayor's representative, and it says he serves at the pleasure of the mayor.
So I don't know where we're really going, and I don't know how we got off on this thing, but it just made good conversation.
yeah.
This is how we learn.
This is our training session.
Yeah.
So my apologies to the board.
Not, don't apologize, but these are the scenarios you start coming up with after a while.
These are the things, like, it's good to talk like this, but now.
You know, where do I defer to? If he comes in one evening
Sure,
and
sir.
he's primed to vote a
Vice
certain
chair.
way, no reflection, believe me, but just as a hypothetical, who do I go with?
What do you mean, if the
The
guy votes
mayor's out,
against
the guy
it?
comes in.
Well, he serves at the
he votes.
pleasure of the mayor, so that'll be his last meeting.
Or mayor's out, the mayor's sick. So you're deferring to the chairman, but the chairman of.
No, the seat is either filled or it isn't.
Right.
The mayor's either sitting there or he's arranged for his representative to come there that night. If it's an empty seat, the first alternate
Takes over.
participates.
And if it's a multi-meeting issue, his alternate has to abstain because he wasn't present, so.
Well, again, I defer to Tony on that one. I'm assuming any alternate would be prepared to read the minutes if he thought he was going to vote. So,
The alternate meaning
His replacement.
from there, or the alternate meaning like
No.
myself?
The mayor's designee is not an alternate. The mayor's
Yeah.
designee is also the class one member of the board.
Okay.
But even a class one member can't vote if he missed
Correct.
the meeting.
Correct.
Right.
Unless,
They swear that they read them.
Then you go to the SIP.
And to think, we had nobody here, imagine if we had business.
We haven't talked it to death, but I think we've got more.
Motion to adjourn?
Motion to adjourn, do I hear a second?
Second.
All those in favor? Aye. Opposed? So carried.